Can an actor trademark the title of a film they once starred in over the producer who created it? This question arises due to the legal issues surrounding the Nigerian movie Domitilla. My name is Olawoye Adejoyinola Oluwasemilola, matric number 2203010008, an intellectual property student of Adejoyinola University, Faculty of Law. In this intellectual property presentation, I'll be looking into the legal issues that arises out of the trademark case between An Njemanze and the producer of the movie Zeb Ejiro of the movie Domitilla. Domitilla is a 1996 Nollywood movie produced by veteran filmmaker Zeb Ejiro, starring actresses An Njemanze, Sandra Achums, Ada Ame, and Kate Henshaw. The movie is about a young woman struggling to make ends meet as a Lagos prostitute. A sequel, Domitilla 2, was released in 1999, and a remake was released in 2023. And Njemanze played a major role in Domitilla 1 and the sequel, Domitilla 2. The producer Zeb Ejiro approached An Njemanze to star in the reboot, which was later released in 2023. According to statements made by Zeb Ejiro, the producers approached An Njemanze to take part in the reboot. Because of the passage of time, the producers considered a supporting role for her rather than retreading the youthful title role which she played in the first movie. But she demanded a much larger sum as opposed to the one which was offered her, and the parties could not reach agreement and the offer collapsed. In September 2020, An Njemanze applied to register Domitilla and Device as a Nigerian trademark in Class 41, which falls under Entertainment Services. The application was accepted and then advertised in the Trademark Journal on 21st of October 2021. In February 2023, after the opposition window had long closed, Zeb Ejiro petitioned the Trademark Registry to cancel the application, arguing that he was the true proprietor of the mark as the producer of the franchise, and the actress filed in bad faith, giving her knowledge of the prior work and the reboot plans. In May 2023, the Trademark Tribunal revoked all documents issued to An Njemanze in respect of Domitilla, finding that she was not the true proprietor and that the filing of the application was malicious and in bad faith. The decision relied on the registrar's powers to correct errors and recall an acceptance issued in error. In the Domitilla's case, the following issues are up for determination. The first issue is who the true proprietor of the trademark is. The second issue is whether or not An Njemanze filed an application for the trademark in bad faith. Whether or not it is the registrar's power to revoke an acceptance that was earlier issued. The fourth issue is whether or not Zeb Ejiro's petition has exceeded the opposition window earmarked by the Trademark Act. These issues stated above will be dissected with the use of the Nigeria's Trademark Act. The first issue is who the true proprietor is. The registrar accepted evidence that Domitilla was a long-standing film franchise created and owned by Ejiro, and that Njemanze's connection was an actress in the film, not as a proprietor of the brand. Section 18 subsection 1 of the Trademark Act states that proprietorship must tie back to origin of goodwill. Therefore, Njemanze's connection as an actress of the movie does not make her a true proprietor, but Feb Ejiro, who is the creator and owner of the movie, is the true proprietor. See the case of Piago vs. Autobahn Techniques Limited, where a distributor tried to register the brand's owner's mark. The court sided with the true proprietor, rejecting the local distributor's attempts. The court's rationale mirrors the proprietorship logic in Domitilla. Participation in the local market doesn't give you ownership of the brand's goodwill. Proprietorship is about the source of goodwill, who originated and controls the brand that consumers associate with the goods or services. In a film context, that's ordinarily the producer or production company, not an actor, unless there's a contract or assignment saying otherwise. The second issue for determination is whether or not the registrar had the powers to revoke the application. Sections 38 to Sections 40 of the Trademark Act give corrective powers to the registrar where entries were made without sufficient cause or contains errors or defects, allowing the tribunal or the court to expunge these entries. This section also lets the registrar strike these entries for breach of conditions and correct certain errors. The third issue for determination is whether or not Feb Ejiro's appeal should have stood despite exceeding the 2-month opposition window given by the Trademark Act. Section 20 of the Trademark Act states that anyone may oppose a trademark application within 2 months of advertisement. However, Feb Ejiro's appeal exceeded this 2-month window. Nigerian law gives the registrar continuing powers to rectify the register and withdraw acceptance pre-registration when a mistake comes to light. The decision given in Domitilla is a strong assertion that accuracy of the register trumps procedural lapses by third party who missed the opposition window, particularly where proprietorship and bad faith are clear. And in Domitilla's case, proprietorship and bad faith are very evident. The fourth issue for determination is whether or not an Njemanze's trademark registration was made in bad faith. The timing of Njemanze's application as she filed as the reboot plans were being made and the relationship of the actor to the franchise supported an inference of bad faith. She made an application after the offer to make her an actor in the reboot failed. Courts and registries, they look at knowledge of another's mark, timing, and intent to block, extort, or free-ride. Filing rights when a reboot is in the works is an attempt to capture leverage rather than protect a legitimate brand of your own, which is the case in the Domitilla. My opinion on the Domitilla case aligns with the ruling of the court. She made a trademark application after she knew that a reboot was in works and after she rejected an offer to become an actress or an actor in the reboot. In my opinion, her application was made with bad faith and the decision of the court and the registrar cancel her trademark registration is right. It is however worthy to note that between April and May 2025, Njemanze appealed to the Federal High Court in Abuja, seeking to set aside the registrar's decision and reinstate her as owner of the trademark. Feb Ejiro's counsel publicly argued that the appeal was dead on arrival. However, this case is the appeal is still pending as the court has not sat on it. In my opinion, to stop the Domitilla's case from reoccurring, producers should do the following. Lock down titles and franchises in Class 41. Producers should file early for trademark in their works. They should make sure that the contracts, either with the writer or the actors, should clearly assign trademark rights in the title, the series to the product entity, so an issue will not be in dispute in future. And you should also make sure that the clauses in the contract with the actors should include that the cast, either the cast, actors, the crew, the distributors will not file trademark for your project title. The Domitilla case reaffirms that Nigeria's registry will prioritize true proprietorship and integrity of the register over rigid procedural cutoffs when there is evidence of bad faith. As stated earlier, And Njemaze's appeal is pending in the Federal High Court. So subsequent changes will be communicated. Thank you.